Great, thank you. So first of all, thank you, Katerina, for inviting me here. I'm very much looking forward to what I think is a very interesting topic and conference. So I think this is probably not worth restating for this audience, but just sort of as a place to start, at least in the abstract, when we think about the modern patent system, when we think about its logic, we tend to think about how patents fulfill the public interest by stimulating innovation, which produces both economic benefit, creation of new markets, economic growth in the aggregate, and social benefit, the availability of new technologies. What's interesting, and is the focus of the research that I've done over the last couple of decades now, is the rise of questions around that seemingly simple logic, many of which have already come up in Graham's presentation and in the response to it. And of course, those questions arise from a variety of places. They've come up increasingly over the last 40 years. There's a variety of different questions around who is really the innovator here, who should receive that benefit, where, Graham talked about the sort of idea that, in the case of Gleevec, for example, there are many potential people involved in the innovation process. We can see that in other cases and histories of science, but also, of course, the individuals who provide the samples, provide the biological samples, what kind of interest do they have and what kind of interest do they have in sharing the benefits. There are questions about whether or not patents are implicitly, in the social context anyway, sanctioning particularly controversial areas of of research and of technology. There are questions and concerns about increasing enclosure of the public domain. Specifically, when it comes to matters related to biotechnology, there's often a concern that arises around the commodification of life forms. And then there's a question about really whether or not patents actually increase access to technology, that in many cases the items that are patented end up being so costly that it's difficult for individuals to access, even those individuals who may have participated in the research process to begin with. So these are the kinds of questions that are swirling around the patent system that many of you in this room are interested in and that ask in your research. There are growing bodies of expertise, not just in legal scholarship, but in the humanities and social sciences and the sciences and medicine, who are asking those questions. But there's also, as again many of you probably know, growing civil society engagement in these questions, a rise of controversies around the world, average citizens taking to the streets, to courtrooms, to bureaucratic spaces to challenge patent systems and patent system institutions about whether or not the patent system is in the public interest, what the public interest really means, and what it should mean in the context of the patent system, what the public interest should mean in the context of the patent system. And those are the sorts of questions that have driven my most recent research and the book that I actually just published a few months ago that came out in March. And in that book, I sort of challenge and look in comparative and historical perspective at the relationship between patents and the public interest, and focus on the last 40 years of controversy around life form patents in the United States and in Europe. Katerina also already mentioned that I focus on comparative politics. I look at these questions from the perspective as a social scientist, perhaps a little bit different than some of you, and I'll talk a little bit more about that in a minute. But I'm interested in law in its broader social and political context, and particularly intellectual property law in its broader social and political context. And the primary argument in the book, Patent Politics, is that political culture, ideology, and history shape in fundamental ways the way we understand patents and the way we understand patent systems, and also then in turn shape the political orders that have emerged around intellectual property even in seemingly similar places of the US and Europe. And of course, when we talk about the US and Europe, we tend to think about these two places as largely similar politically, economically, in terms of its science and technology capacity. These are two places that have been at the forefront of harmonization efforts around the world in terms of intellectual property. When we talk about life form patents in particular, there's often a focus on the ordre public clause as being the operative difference between the United States and Europe in terms of these two places. And in the book, I'm not going to talk too much about this today. I'm happy to discuss it a little bit in the questions. In the book, I talk about how, the ordre public clause tells us something, but it doesn't tell us nearly enough. It's not a deep enough explanation, and I try in the book to give a deeper explanation, because there's a number of questions that the ordre public clause raises. That is, why is there an ordre public clause in the US? Why does it take on the meaning, in Europe? Why does it take on the meaning that it has in contemporary debates about biotechnology, when in fact historically it had a somewhat different meaning? Why is it that while there is on the books in the US context similar language, why doesn't it get invoked? And for me, the answers to those questions are social, political, and historical. But what I want to focus on today is to really focus on how these political contexts shape the kinds of questions that we ask about patent systems, the kinds of data that we generate, the way we envision the problems with the patent system, as well as the way that we envision solutions. So my hope is that this, in sort of more normative discussions about how, how to address the challenges, the IP challenges, the ethical challenges that IP in the context of personalized medicine might raise, that it might provoke us to reflect a little bit on why we're asking those questions and not other questions, and the fact that, in fact, our approaches to these questions are very much shaped by the context within which we're operating. So as I said, I am a social scientist, and an empirical one at that, but I do qualitative research, and I use qualitative interpretive methods. That means that I use a variety of different kinds of qualitative methods, the historical record. I also do interviews, I do ethnographic observation, and I think for the purposes of this audience, it might be worth my taking a few minutes just to talk a little bit about the work that I've done, particularly for this project and for this book, to give you a sense. And basically, I take a variety of these different kinds of data and then use them to identify patterns in those data to make broader claims, as I said, about the relationship between political context and the patent system. So in the book itself, there's a sort of a historical component, and then there's a more contemporary component. The historical component takes us from the early days of the patent systems, from the privilege systems in the 16th century, and uses a number of secondary historical sources to do that. But then I focus my historical analysis on the sort of from the rise of the modern patent system to the present. So I look at, for example, the history of congressional hearings in the United States around patent systems, court decisions and the amicus briefs filed in those contexts, European documents related to the development of the European Patent Office, recent archives related to the European Biotech Patent Directive, in order to build a story around the histories of these systems, and then to understand the more recent controversies, where I focus on controversies around human genes, human embryonic stem cells, genetically modified plants and animals, cDNA. I use a mix of methods. So I analyze the patent prosecutions, which run into the tens of thousands of pages sometimes, especially for the more controversial cases, but are incredibly rich sources of data, especially when you're looking at controversy, because on page 6050 you might find a few lines that tell you about the ways in which the opponents to particular patents are talking about their concerns and the ways in which the European Patent Office or the US Patent Office is responding to that. So I went through that. I developed a database around the different controversial patents in the US and Europe that includes about 150 patents in the two places, and then also, as I said, did a deep analysis of the most controversial cases in terms of the patent prosecutions. I did about 120 interviews with US and European Patent Office officials, other government representatives involved in patent system institutions, interviews with activists and other challengers, patent lawyers, legal scholars, and industry representatives. I attended congressional and patent office hearings, meetings, and conferences, both in the United States and in Europe. And then I analyzed documents from patent offices and challengers as well that are more publicly available outside of the patent offices themselves. So after that set of kind of somewhat messy, at least on its face, data, as I said, came up with an argument around the role of politics in the patent system, but I want to drill down a little bit into that for today's talk and tell you a little bit about what I mean when I talk about the relationship between political context and the patent system. So what I argue in the book is that there are basically very different approaches to the ways in which the US and Europe think about the role of government and the market, relative roles of government and the market vis-a-vis innovation. So I talk about how in the United States context, we have what you might say is a market-making approach to innovation. That is, that the role of government is to create the conditions for a successful market to thrive, and this I think is an important point, and I'll come back to this later, that moral order is produced by a well-functioning market. To put it differently and maybe a little bit more succinctly in one case, the consumer, rather than the bioethicist, is the ultimate moral arbiter in the US context. And they make their moral decisions in terms of what products are available, but then also what products are actually purchased. By context, I argue that in the European context, there's a more market-shaping approach where the government has a larger role to play, reflecting a larger moral order, and shapes the market according to the rules of the moral community that operate outside of the market. So the moral order shapes the marketplace. And that, then, I argue, produces different patent system logics. So to go back to where I started, I argue that there are actually different understandings of the public interest that emerge in the US and European contexts. It leads to different kinds of institutional frameworks, practices, norms, as well as the law. So what you can see, I hope, to begin with, and I'll get a little bit more into the data in a minute, but I am interested in the legal texts and the legal decisions, but I'm also interested in the kinds of programs, bureaucratic decisions, practices in the US and Europe in patent system institutions. And so I see those differences emerging not just in legal decisions, and sometimes not even in legal decisions, but often in other places in the bureaucracy and other kinds of laws and other kinds of relationships between patent system institutions in the two places. And so I'll talk today a little bit about the different patent system legacies in the US and Europe and how you see this even early on in the histories of these two places. And then I'll focus most of my attention on biotechnology and biotechnology's early days, and then talk about two cases comparatively, the stem cell cases and the human gene patent cases, which I think provide some interesting fodder for thought when we talk about the personalized medicine context that I know is the focus of the conference today. And a couple of the things that I want to call your attention to now, and I'll return to throughout the presentation, is that I argue that what this means, right? So what the consequences are of different kinds of political orders emerging in the US and European context means that responsibility gets distributed differently across patent system participants. So for example, the government might take on a greater role in the European context, whereas there's much more trust in the innovator to make morally correct decisions by virtue of them doing morally correct work as innovators in the US context. And then second of all, you'll also see that the evidence and expertise for patent decision-making and policy are also quite different in these two contexts. And this is something that we tend to not think about. We tend to think that the relevant evidence and expertise for policy is self-evident. But I think it's really important to drill down into this to see how politics shapes, even, as I said earlier, the kinds of questions that we ask, the way we frame problems, the way we understand what constitutes relevant solutions, but even the kinds of data that we marshal and the kinds of expertise that we marshal in those discussions around patent decision-making and policy that are also very important. And as I said, my hope is that by doing this kind of analysis, it can bring a little bit more transparency and opportunity for reflection as we have discussions about the ethical and social dimensions of intellectual property and patents in particular. So to start by giving a very broad overview in terms of the legacies of the US and European patent systems, in the European context, one of the things I argue in the book is that, of course, in the European system, just as in the US system, there's a focus on patents as being innovation and market drivers. So it's not that the logics are entirely different in these two places, but I argue that it's not just that they're innovation and market drivers, but also that for a very long time, patents have also been seen as fundamentally moral and socioeconomic objects as well. We see this even in the early privilege systems, that public interest limits are placed on those early privilege systems. They're incorporated into the Statute of Monopolies in 1623. There's public interest language that today we talk about as an ordre public clause. But at the time, that language was focused on questions of riots and public disorder, and in particular, privileges that were placed on salt and oil that were actually really about the socioeconomic implications of patents, that they could, in fact, reduce access, and this could create social problems. And so there needed to be language in patent law in order to address those kinds of cases. Those, of course, were then incorporated into modern, more rights-based patent systems in ordre public or public policy language. And at that time, still was tied to socioeconomic implications. So in the 19th century, you also have that kind of language, but you also have categorical exclusions on food and pharmaceuticals, again, based on concerns about the socioeconomic dimensions, about the potential monopolies that might result. And so one of the points that I want to make here is that there's a distinction between the public interest and the inventor's interest. And we've already used the word balance quite a bit today, right? So there's a balance between the public and the inventor's interest, and it's the government's responsibility to perform that balancing act. In the 1970s, of course, the European patent system comes into force. It echoes this approach. It gets rid of a number of some of these dimensions, but it maintains an ordre public clause. It maintains some categorical exceptions, despite the fact that it's seen largely to be a move towards the US system and a move towards international harmonization. In the US context, of course, again, this is a system that is very much about driving markets and innovation, but I argue in the book that patents are seen primarily as techno-legal objects in the US context, in contrast to moral and socioeconomic objects in the European system, and that's the distinction that I'm drawing there by using those kinds of terms. So there are some limits early on in the development of the US patent system in terms of attempts to kind of, obviously there are attempts in the life of, limits in the life of the patent, but early on, many of the provisions in US patent laws were designed to encourage everyone to participate in the patent system. So application fees are kept low, there are public displays to encourage excitement about participating in the innovation system. And there's a bit of work, Zarina Khan has written a book called The Democratization of Invention, mentioned, Mario Biagioli has written quite a bit about this. The idea is that, you know, this is sort of a fundamentally democratic system because everyone is encouraged to participate, right? The flip side of thinking about it as a democratic system, of course, is to then assume that the inventor's interest and the public interest is essentially identical, right? And so that is also a fundamental part, I argue, of the US approach to the patent system. And in fact, as the patent system evolves and matures, as the European systems are developing categorical exclusions and later on compulsory licensing legislation, there are multiple attempts in the United States to create similar kinds of laws. But at each of those points, there's great resistance, not just from the innovation and intellectual property communities, but from Congress itself that says, you know, the inventors are doing essentially God's work. They're doing the people's work, right? So you're creating a false dichotomy when you distinguish between the public and the inventor's interest. And that idea even continues today in the debates around biotechnology, which I'll talk a little bit more about in a minute. So that's one dimension that I think is important. The other dimension is that, of course, as many of you probably know, the US was the originator of a systematic technical approach to patent examination. So while the French system had scientific advisors as part of its early patent systems, the US systematized this. They made a big deal in the early patent laws about ensuring that only the best scientists and engineers with the greatest training could participate as examiners in the patent system, and the real focus was on producing procedural objectivity. That is, not just adherence to the law, but adherence also to science, to taking prior art, to being very much evidence-based in its decision-making. And I point this out for a couple of reasons. So there are a number of scholars of science and technology policy and science and technology studies, the field that I come from, that has demonstrated through other kinds of comparative analyses, notably primarily in the area of risk regulation, that the US approach tends to focus on thinking about the public interest and thinking about adherence to democratic principles through a focus on procedural objectivity. So that's, in those contexts, how the US system reflects the public interest and demonstrates that, in fact, procedural objectivity provides this appearance of transparency, and that is fundamental for a democratic society. And you see that here in the patent system as well, that it is also focused on producing this kind of procedural objectivity as a means of fulfilling the public interest and fulfilling specifically democratic objectives in terms of the public interest. So that's, I think, another important dimension. So you can already see that there are a couple of dimensions that are quite different in these two places, even though on their face they don't actually look so different. And of course, we know that in the European context, now, of course, there are similar technical approaches to examination in Europe as well. But it's important that I argue that it's important that it's the US that promotes this and develops this during a progressive era in the United States that's focused on emphasizing procedural objectivity. But what you see is that there are different ideas about the public interest, different understandings of the public interest, and different understandings not just of the government's role, but also of the relative roles and responsibilities of the participants in those patent systems, most notably the moral responsibility and the morality of inventors themselves, in particular the idea that innovators in the US context are morally responsible and should be left to work, and that they will produce socially beneficial results. So then to fast forward a little bit, as we all know, then in the 1970s and 1980s, the first questions around life form patents emerge. And there's an explosion of questions, right, that has been discussed quite vigorously in the literature, in the legal literature, but as I said, in the humanities and social science literature, around what the status of life form patents are, right, about whether or not life form patents are life forms are technologies, or their patentability. I argue that these are not just questions about whether or not life forms are technologies, whether these life forms are life at all, but also at the same time, there are questions being asked and answered about who should make these decisions and how those decisions should be made, what the role of the patent system is more broadly in the context of science and technology policy. So in the United States, I think it's very notable that the patent system we know about the Diamond versus Chakrabarty case. I'm sure almost all of you in this room know a little bit about this case. That was the first case that hit the Supreme Court around this question around life forms that involved the patentability of a genetically engineered microorganism, and specifically whether or not it was a product of nature. But if we step back for a moment, and we look at it comparatively, the interesting question for me is that it gets asked and answered in a legal context, initially in a bureaucratic one, but it gets kicked up to a legal one, even though there are attempts at various points to make it a political and a policy question, and also to raise ethical, social, and ecological questions. So Jeremy Rifkin builds a coalition of different kinds of advocacy groups, submits an amicus brief as from my research, the first time such a civil society group files such an amicus brief in a patent case, and asks these kinds of questions. Says, the legal context, the courts is not the appropriate place to have this conversation. To have this kind of conversation, the democratically elected representatives and the public should be involved. That means it should be in Congress. He says that these are questions that are fundamentally about ethics, society, and the ecosystem. And again, the court is not equipped. The product of nature doctrine is not sufficient to have these kinds of discussions. They need to occur more broadly. But the court shuts it down. The other amicus briefs shut this down. The court also shuts this down. And essentially they say, listen, you're raising irrelevant concerns. These are not relevant. You don't understand the way the patent system works. I'll get back to that in a minute. But they say, the patent system is incredibly limited. It's just an administrative law domain. It doesn't do all of these things, and so you shouldn't be asking these kinds of questions. What's interesting, I think, and should give us a little bit of pause, at least to begin with, is, of course, the history of this issue in the European context, where initially, the European Commission essentially tries to do a similar thing, which is to treat it as a narrow technical and legal question. They propose the directive, the EU directive for the legal protection of biotechnological inventions to the European Parliament, but almost immediately, the European parliamentarians, they give it to a group of advisors, including labor unions and farmers and breeders, and almost immediately, it takes on a much more complex dimension. There are a number of working groups formed in the parliament, from fisheries to international rights, and they all say, no, this is in fact a much broader set of questions. This is not a technical set of questions, and we need to have a much broader discussion. Right? So again, you can see this sort of idea, what kind of question is it, and what kind of evidence should be brought to answer this question is already immediately different in these two places. Now, most of you know the resolution of this story, so I won't belabor it too much, but one of the points that I want to just highlight is that the Ordre Public clause comes in a major way. It's defined in a number of ways in the final legislation. There are a number of clauses, including that, for example, that there's a weighing up test created around animals where the benefit to humankind is weighed against animal suffering. There's a clause that I'll talk a little bit more about in a minute that prohibits the inventions that involve the commercialization or exploitation of a human embryo. But the point is that in this iteration, this biotech directive also helps to produce an understanding of the ordre public clause that is focused on bioethics, and a modern bioethics interpretation at that. Far cry from the socioeconomic dimensions that it had earlier. And in fact, it's quite interesting as later on that the European Patent Office, in fact, ultimately rejects the idea that the ordre public clause deals with socioeconomic dimensions and is a purely bioethics version. Now, these seem like good settlements, but as we all know, the concern and controversy has continued in the decades since. There's been enormous concern among civil society groups, patients, scientists, physicians that have mobilized both in the United States and in Europe. The first set of controversies in the 1980s and 1990s focused on animal patents, and then it has continued since. And in those early years, I mentioned that the reaction to the Rifkin brief in the Diamond versus Chakrabarty case focused on how, you know, these unwashed citizens didn't understand the complexities of the system. They misunderstood what the system was about. They were ignorant about it. And that continues in the years since. In every case, you see a different version of it. And what I argue in the book is that what has happened is that patent system institutions, particularly in the US context, assert what I call expertise barriers. And these are formal or informal rules that policy domains produce that evolve over time and that shape the way that a domain defines appropriate avenues for participation, as well as definitions of relevant knowledge and expertise. And in this context, in the patent system in particular, I argue that these are rhetorical, but these are also legal and bureaucratic barriers. So for example, in the US context, you see legal standing rules that make it very difficult for folks outside of the domain to participate. You have bureaucratic practices that ensure that outsiders cannot participate in the domain. You have even the structure of public comment mechanisms that make it very difficult for those who are not patent lawyers, agents, or innovators to participate in the domain. Meanwhile, over this period, the European patent system institutions are struggling to comply with the directive, and in more specifically, to create bureaucratic spaces for ethical reasoning. So an example of that is how they struggle to figure out how to interpret the weighing up test. Is it an evidentiary test? Do we think about it in an abstract way? Do we think about it in terms of a, you know, it's a utilitarian framework, but what does that actually mean in practice? And also begin to develop new understandings of public accountability. So, you know, what does it mean to have these oppositions and these people who don't know the conventions of the patent system to participate? What does it mean to have a public hearing? Do we invite them in? Do we make the transcripts available? All of those kinds of questions are being addressed at the same time that the US system is saying, no, these people don't belong. These questions don't belong. So as I said, I'm going to now focus on just a couple of cases that are not specifically about, well, the gene patent case is obviously much closer, but I wanted to talk about these cases because I think that they tell us some interesting things and perhaps give us some opportunities for reflection. And the first is the human embryonic stem cell debates, human embryonic stem cell patent debate, in the United States and Europe. So this is a debate that's relatively recent, although nowadays stem cell research and excitement surrounding it seems so long ago. But as you probably know, human embryonic stem cells in the US, the debate began in the late 1990s with the work at University of Wisconsin by Jamie Thompson, who was able to isolate and propagate human mammalian embryonic stem cells. And immediately, there was an enormous debate that emerged in the US context around the ethics of stem cell research, the destruction of human embryos, concerns about whether this kind of research was ethical. Soon afterwards, George W. Bush was elected and placed significant limitations on federal funding for research, and in particular limitations that focused on funding for lines that had already been created. At the same time, University of Wisconsin applied for a patent and they licensed that to the biotechnology company Geron. And early on, Geron was offering licenses, but at very expensive rates to academic and nonprofit institutions, and even more expensive rates for for-profit researchers. So in the context of perception that stem cell research was being severely restricted in terms of NIH funding from the Bush administration, and in the context of Geron, there was an active debate about the right of research right to research, and the idea of a right to research emerged in the US context, and there was a lot of discussion about it. And there was a concern in particular that University of Wisconsin's patents and the licenses would disrupt science, that it would be deeply problematic, that it was interfering with a right to research. What's interesting is that even though there had been concerns about commodification, concerns about the ethics of biotechnology, the ethics of genetically modified organisms, even though at the same time there was this active set of debates around stem cell research and its ethics, those concerns did not touch the debate inside the patent system. Instead, the debate in the patent system was about access to research and the ability to do research. And one of the things I argue in the book is that by this point, in the late 1990s, it was no longer acceptable to have a debate about ethics in the context of the patent system. And so those people had essentially given up. In fact, a number of those people had switched their arguments and began to make arguments about the right to research in the US debate. So there are also, at the same time, there are active congressional hearings that are happening around patents, and there are really interesting debates where the senators and congresspeople will say, right, today we're going to have a debate about patents, and tomorrow we're going to have a debate about ethics, right? So they're very much compartmentalized as being very separate issues that have very separate sets of questions, data, and solutions associated with them. And interestingly, and I make this point because I think one of the important points that the stem cell debate tells us is that there's a move towards saying, you know, the government doesn't really have a role to play in this. It's really about the market, and the market players can be trusted to essentially regulate themselves. And as though, you know, to demonstrate that in the middle of congressional hearings about whether or not patents are hurting access to research, Geron announces in a memo that it's going to change the way that it negotiates licenses to academics and nonprofit institutions. Around the same time, California, also concerned about the Bush-era policies, establishes through a referendum a large institution, a $5 million bond, to start this California Institute for Regenerative Medicine. And there is an IP task force that's created, and there's an attempt to establish a research exemption and access to healthcare provisions so that California taxpayers, for example, would get lower cost access to therapies if any therapies result. But relatively quickly, once the draft of that policy is published, the biotechnology industry, which is very powerful, certainly in the California context, vigorously opposes this, and the task force members who had initially said, you know, it's immoral for us to force taxpayers to pay twice for these kinds of things, relents and says, oh, you know what? On second thought, we're not really experts. The biotechnology industry knows what they're doing, and they say that this doesn't happen very often. So, you know, I think we should. They're working on our behalf. And one of the things that's very interesting, and I think bears special attention, is that there's an interesting example, and this goes to, I think, this question about evidence and, you know, what it means to have sufficient evidence of the social costs or benefits of patents or licenses. And as I said, from my perspective, that's a deeply political question. Is that in this debate, right, at the same time that people on one side of the debate are saying, listen, there are these really important examples, for example, the Myriad case, where patents are having these kinds of impacts on access, the biotech industry responds by saying, oh no, there's only one case, right? So the relative meaning of a case and how it is interpreted in these contexts is shaped by the interests of the players involved. The patents are amended after re-examination, and as I said, this IP debate essentially excludes discussion of social and ethical implications in the US context. Now, many of you probably know the story in the European context, where government plays a much more strong role in a different one. So the history is somewhat different here. It is instigated by a patent that is issued to the University of Edinburgh, also around the same time in 1999. Civil society groups and governments file formal oppositions on the basis of a violation of the Ordre Public Clause, and in particular the clause in the European Biotech Patent Directive that talks about preventing inventions that involve the commercialization or exploitation of a human embryo. The filings in that case focus on questions of commodification and human dignity, not so much the right to research. Of course, by that point, there's language around a research exemption in the Biotech Patent Directive, so that issue has been taken off the table to some degree, at least in the way that it emerged in the US context. But there's another piece of this story that I think is important, that takes us beyond what's happening in the patent office, which is that the European Parliament issues a resolution, a non-binding one, but a majority one, that condemns the EPO decision, questions whether the EPO is publicly accountable, notes that no consideration of research and still less of profit can be allowed to override that of the dignity of human life. And I quote that here for a couple of reasons. The first is to return us to this discussion about public accountability. I talked about how in the US context and in the history of the US context, there's a focus on understanding public accountability in terms of procedural objectivity. And in the European Parliament's eyes, the EPO is not engaged in publicly accountable work because it's not responsive enough to public concerns. And that's a very different understanding of public accountability. And the second is a focus on concerns about the dignity of human life that are arising centrally in the context of the European debate. Ultimately, the European Patent Office rules that human embryonic stem cells are contrary to ordre public and unpatentable, and then in further decisions that gets reinforced. But my point here is that European patent system institutions are operating according to a different kind of understanding, both about their role as a balancer and also about the nature of what constitutes the public interest in the European context. And we see that in other kinds of bureaucratic ways inside European patent system institutions, and the EPO in particular. They develop a sensitive cases system that flags certain classes of applications. The US tries to do something similar, but it essentially fails very quickly, in part because it has not produced a bureaucratic culture to support that kind of work. There's also policy initiatives like the Scenarios for the Future report that was published in 2007 that attempts to see the European patent system as part of a larger apparatus for governing emerging science and technology. And there are a few other initiatives like that, efforts, for example, to assess the patent environment and things like clean energy, et cetera, that demonstrate a different understanding of the patent system's role. So I only have a few minutes, but I want to just say a couple of things about the human gene patent cases in the US and in Europe. So, we've already talked, Graham already talked a little bit about the Myriad case, and Myriad Genetics was and still largely is, partially because of its proprietary database. It owned the patents on the BRCA genes. It had a monopoly. Outsiders to the while these patents had constrained access both for researchers and for healthcare providers, and these are things I talked about in my first book. It had promoted essentially acceptance in the US context, the idea that, this is the price we pay, we've accepted this, that this is the way that it works. It's notable that outsiders, the American Civil Liberties Union, spearheaded an attempt to challenge that, and they kind of got around what I called the expertise barriers in the US context to do so. And as you know, probably, that in 2013, the Supreme Court ruled that isolated genes are unpatented. But on the way to this decision, and since this decision, there are a couple of things that I think are important to note. The first is that along the way to this decision, the US Congress had passed in 2011 its America Invents Act, and as part of it, it ultimately asked the Patent Office to do an analysis of whether gene patents impact access to diagnostics. And in the hearings, these forced hearings that the Patent Office had, a few things are clear, right? The first was extreme discomfort with the question. So the hearings would begin with the deputy director saying, there's a false dichotomy between access and patents and healthcare. This betrays a misunderstanding of the system. And all of the witnesses sort of echoed this. They said, people are talking about the idea that patents hurt access, but actually, that's the problem of healthcare and health insurers. It's not a patent system problem. And so, this is sort of repeated in all of these hearings over and over. And then ultimately, the Patent Office report that's published in the fall of 2016 says, right, so yes, there's some evidence, but actually it shows that that patents don't really, that gene patents never had this kind of impact on research and healthcare. And so, again, this goes to the point not just of what kind of evidence is being deployed, but also how it's being evaluated in these contexts is shaped by the sort of presumptions about what the system is designed to do. The contrast is, of course, the European system. Now, it's important to note that while the myriad patents were revoked in the in the European system, they were done so on technical grounds, not due to ordre public. And in this ruling, the European Patent Office notes that the ordre public clause is only related to ethical questions, not socioeconomic questions. But if we look again broadly, we see that there are a number of countries that pass compulsory licensing laws focused on gene patents. In this context, the single case on a major gene linked to a common disease becomes enough evidence to spur this kind of legislative action. And the socioeconomic concerns come back, as I suggested, in other kinds of policy arenas in other institutions in the European Patent Office context. So, to return to the kind of basic points that I wanted to convey today, I wanted to suggest first and foremost that the way we think about that there's a broader political context that shapes patent systems, its institutions, its political orders, its understandings of knowledge, relevant knowledge, expertise, appropriate participants and avenues of participation, but that the US and Europe, when we think about them, they provide a good comparative case because they appear similar in so many ways, and yet they think differently. And that's sort of what I'm trying to get at here. And that at the US system, for example, the idea is that market players have an interest in ensuring widespread access because more customers leads to more profit, and they have moral responsibility. Governing institutions play a much more limited role, and you even hear this in conversations that are occurring now about, lauding the Broad Institute for creating ethical licenses around its CRISPR technology. In the European context, there's much more of an idea that the government has a moral responsibility to shape the marketplace, that public and inventors' interests are not always the same, and that market players operate in their own self-interest, which can, on occasion, produce socioeconomic and ethical problems. So, in sum, I think over the course of the next couple of days, we will probably have, at least judging from the titles of the talks, a number of conversations about government-based versus market-based solutions. And I think one of the things that I like to introduce into the discussion is sort of what are our presumptions as we're having those conversations? How are we evaluating the evidence? What are our assumptions about what constitutes evidence in these contexts? And to introduce that to hopefully produce some kind of reflection about it, and also to think in really serious ways about what the relative risks and benefits of government versus market-based solutions tend to be, especially because I think in this context we tend to focus much more frequently on market-based solutions. Thank you.
Thank you.